This is the Unregistered podcast, and I'm Thaddeus Russell. This is a show about ideas, people, and behaviors that are considered inappropriate, out of bounds, or beyond the pale. The things you're not supposed to talk about if you're a school teacher, a college professor, a businessman, a politician, a parent, a neighbor, or even a podcast host. These are the things you're not supposed to say or even think if you're a good liberal, a good conservative, or a good citizen. Each week, I'll interview a person who has something bad to say. They might be a journalist or a professor. They might be a porn star or a drug dealer. They might just be an ordinary person with an ordinary job who doesn't care about the rules of polite society. I'm not interested in breaking the rules just to be a troublemaker. I'm interested in people who break the rules of conventional thought and to expand the scope of what is possible to say in our society. I'm interested in people who make me think. People all over the country and all over the world right now are very angry about police brutality and mass incarceration in the United States. What very few of them know is that, at least according to this week's guest, one of the major causes of that brutality and over-incarceration was the feminist movement of the last 150 years. This is my interview with Aya Gruber. I am here with Aya Gruber, who is in Boulder, Colorado. Is that right? You're in Boulder?
Boulder.
And you are a professor of law at the University of Colorado Law School, correct?
That's right.
So far, so good. And you have just published an incendiary book.
I like incendiary. I'll take that.
It should be incendiary if people understand it. You ever have that experience where you say or write something really provocative and controversial, but people don't get it and they sort of think it agrees with them, but it actually doesn't agree with them?
All the time.
Yeah.
And especially, when you're trying to hedge your arguments and be good faith to all the arguments on either side. And especially if people aren't reading carefully, they'll be like, I totally agreed with this. And you were really characterizing somebody else's argument that you disagreed with. Yeah.
So however, I think with your book, this will not happen because just the title itself is, as soon as certain people see it, they're going to get their backs up and accuse you of a lot of stuff. So just tell us what the title is and people will understand why it's going to be incendiary.
Yes, the title is The Feminist War on Crime, the unexpected role of women's liberation in mass incarceration.
Now, the feminist war on crime, if you take the title alone, one could sort of interpret that in various ways, I suppose. But your argument, in a sentence or two, is that feminists, really since the 19th century, right, have been promoting, usually successfully, laws and policies that have contributed tremendously to two things that we are very concerned about, especially these days: mass incarceration and police brutality, right?
Yes.
And that's a pretty heavy charge you're making against feminism over the last 150 or so years. And so I would imagine that once they get a hold of this, after this podcast comes out, that you should get some criticism, as you should. My point is that if they understand your argument, you should be attacked. And so you should welcome attacks.
Yeah, I do. Although, it's funny because the book is not officially out yet. It can be ordered on Amazon and I think it's shipping, but the official release date is the end of the month. And I think it was even the first review on Amazon said, I haven't read this book yet. But if they're going to say that feminism is the sole cause of mass incarceration, that can't be right. And, I agree. If somebody said feminism is the sole cause of mass incarceration, if anybody said anything is the sole cause of mass incarceration, right, you could say, okay, that's stupid. But, I would love that to be the straw man argument, because I take hundreds of pages explaining that this is a very complicated story of resistance and strategy and all kinds of things within a moving culture and a moving legal and socio landscape. So no, it's not simple. It's not a simple linear story. It's a messy story that you really have to dig down deep into. But I thought that was funny. If that's the straw man that I'm saying feminism is the only cause of mass incarceration, I'll be happy with that, because they obviously didn't read the book.
Yeah. You're going to get a lot of that. Welcome to the world of public intellectualism, Aya.
Thanks.
This is what happens out here. It's not pretty. So, you're aware that I'm an American historian, right? With a PhD in history, taught history, American history.
Yes, which intimidates me because I have history in my book and I am very far from a historian. I'm a lawyer.
Yeah, well, you should be intimidated because I'm an expert. Okay, so you should be quite nervous right now, and you should be nervous because your history, your book is largely, or in large part, a history. You tell the history of this phenomenon of feminists urging increasingly carceral solutions to domestic violence and rape, et cetera, from, as I said, from the early 19th century or mid 19th century to the present. So I'm here to tell you something. It's really good.
Really? My history is good?
Yeah,
oh, good. Okay.
It's really good.
Thank you. Thank you.
I have studied, taught, and written about almost exactly the issues that are discussed in your book. And you do a great job. You do a great job.
Thanks. I rely on historians. I mean,
Yeah.
I did a little bit of my own research, but I didn't do original archival research. I figured if let me back up. I have for 20 years now been writing about the tension between feminism and either civil libertarianism, you might want to call it, or being sort of skeptical of the police or the prison state, or you could call it a feminist public defender dilemma. So I've been writing on that for years, but in a very legal frame. Like, okay, this is where feminists are at now, or for the last, say 15 years, and they've been really carceral, and look at these policies and laws that are being produced, and they're really not that good for women, and they're really bad for men. And so I had been just in that sort of highlighting the fact of carceral feminism for many years. And then I would hear these what I call sometimes feminist folk knowledge tales about how we got to this point of carceral feminism. And they sort of invariably involved this history of a male sexual license and rampant abuse and failed feminist reforms. And oh my God, we've got to do something now and it's long overdue. And then you would also hear this narrative, and to the extent that it went overboard and got feminist, well, that's not feminist fault, right? That is prosecutors' fault, and they co-opted and Reagan and da-da-da. So there were these two feminist folktale narratives, one of linear under enforcement, and then one of, feminists always meant good. And I said, okay, this is what I've been hearing for 20 years. Is this true? Is that how we got to this place? And there were no books on it. No books told us the total story of how was it that feminism, in the latter 20th century got so darn carceral.
Yeah.
And I was actually really curious. And if it was going to be a story of total co-optation, that's what it would have been. If it would have been a story of, there was this rampant, persistent, linear license, and law enforcement was really sexist and they needed to go in there. If it was only that, I would have written that. But it turned out to be just so much more and so interesting. And feminists and women had so much more agency in these stories.
Yes.
They were really making a difference.
Yes.
And I think the reason that that's so important to know is, I think part of having cover to do a lot of hasty and off-the-cuff law reform is you think, well, they haven't done law for so long, and there's this big problem of DV and rape out there, so let me do law. And then you get these laws and they turn out to have all these effects and costs. But I just think if some young feminists understood, no, this has been done throughout history. They were really powerful actors, and they put into place these laws against rape and domestic violence and human trafficking. And even back then, they were really controversial and they had all these effects. It would take away at least that part that makes people quickly jump to these carceral solutions.
Yep. So I've been telling you for many weeks now about this great new company called Paloma Verde CBD, which is the sponsor of the Unregistered podcast. It's owned and operated by Vanessa and Carlos Abelar out of San Antonio, Texas. And I just got off the phone with Carlos and Vanessa, who are very excited about how many unregistered listeners are now their customers. And they also wanted to tell us that they have a couple of new deals for us. So first of all, they have a frequent flyer kind of program where if you buy a certain number of products, you get additional discounts. And in fact, there's one unregistered listener apparently who is a 4-time customer. So Vanessa and Carlos wanted to reward those people. On top of that, they have a new mailing list, an email list. And if you just join the email list, you get an additional 10% off your first order. So go to palomaverdestore.com, use the discount code RENEGADE for 25% off, and join their email list for an additional 10%. That's a total of 35% off the products. Go there, improve your life. I promise you'll love the products. Okay, so I want to walk through the history from beginning to end. First, I want to do a couple things with you. First, I want to talk about this term carceral feminism.
Yes.
Right? Which I believe, I know was coined by my former colleague, Elizabeth Bernstein at Barnard College in,
Correct.
I think, 2007 in an article. I think it was 2007. Yeah.
That was the first time I could find that she used it, although I think it got more popular after 2010.
Right. So that was like a year after I left Barnard. But she coined it. And then there have been, how many scholars would you say have been sort of on her side in this in terms of critiquing feminism as being carceral, right? Like how many people? I mean, I know I can think of like 3 or 4, but like, what would you
Elizabeth
estimate?
Bernstein did a lot of the critiquing in the international law space and the human rights and development space. And so I would say there are a lot of like left scholars who would agree with that critique. Mm-hmm. Karen Engel at Texas is coming to mind, Janet Halley at Harvard. In fact, the whole Harvard International Global Law and Policy, they have groups in India. I'm thinking, she works in London, but she studies sex work in India. I'm thinking of Prabha Kotiswaran. So within the international space, there have been many critics of this tendency of sort of a carceral mode of second wave feminism to be exported into other countries via the language of human rights.
Yeah, wow.
And so I've seen that critique. In the US space is very interesting, but I had been writing about, whether being really tough on sex offenders was a feminist move, probably since the late 90s. Mm-hmm. And there weren't a ton of allies in that space. In the American criminal law of rape shield laws, affirmative consent, there was pushback from civil libertarians. Mm-hmm. But were there, sort of legal scholars and feminists saying, we're going too far with domestic laws on date rape and sexual assault and groping and things like that. And there weren't that many until the Title IX situation arose. Yeah. And then I think the Title IX situation really activated people to say, wow, we really are counting many sexual things as rape that before we might not have thought as rape. We really are collapsing these continuums, as Janet Halley would say. And we're really being hostile to due process in a way that, really raises my civil libertarian hackles. Mm-hmm. So at that moment, most of the panels I was on, people were expecting people to be really pro Title IX, and then were surprised when everybody started their talks with the caveats you have to give when you do this kind of critical work. I think rape is terrible. I'm not for rapists. I think there needs to be justice, right. But blah, 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 blah. And most all of the legal scholars had some blah, 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 whether it was about like not having hearings or counting all drunk sex as rape. Like there were a lot of caveats there. So that's when I started seeing a lot of pushback in the Title IX space, so much so that the Title IX advocates were really taking pains to say, look, the reason why we're against process here is we don't think a lot is at stake, but we're totally on pushing more criminalization. So
there's some people who don't know, like when you say Title IX, what are you talking about here?
So Title IX was the controversy that started around 2011 when there were these sort of explosive news reports
Mm-hmm.
of a campus rape crisis, and how, women going to colleges were getting sexually abused sort of left and right.
Mm-hmm.
And once that happened, the Obama administration, Department of Education, Office of Civil Rights, issued what's called a Dear Colleague letter. It's this form of administrative guidance. And basically what it was doing was it was telling schools, how do you interpret the federal law? And the federal law is Title IX of the 1972 Education Amendments. So shorthanded as Title IX. So this letter basically said to schools, we think that campus rape is a pressing crisis and an epidemic, and this is a call to arms. And then it was fairly wishy-washy after that. The concrete things it did was say you cannot mediate out these cases.
Mm-hmm.
You cannot, you probably should not, I should say it that way, have the parties cross-examine each other face to face.
Mm-hmm.
And when you're judging these cases, you should use a preponderance of the evidence standard, which basically means, is it more likely than not that the assault occurred? You can't use a clear and convincing evidence standard, which is a higher level. So those were, that's not that much guidance. In the end of the day, that's not much guidance, right?
Mm-hmm.
But what was maybe de facto a lot of guidance was the DOE launched into a series of lawsuits
Mm-hmm.
against college administrations. And in the height of this lawsuit era, it was something like 500 some odd lawsuits.
Mm-hmm.
And, are schools scared of losing money? Yeah, they're scared of losing money. What are they more scared of? It getting out that they were found responsible in a lawsuit that said they didn't take rape seriously.
Right.
So this was something that, the college bureaucrats ran with, right? And also it was on the right side of the discourse. So the tougher they could get on sexual assault and the more they could sort of expand the definition, the better it was for them. But the problem is the more you expand the definition, the more you actually making yourself liable. Because if you don't go after every single suit in a perfect way, then you'll get sued. So then what the administrations did was a brilliant thing. They shifted the responsibility to faculty, right? And so faculty are now early and often mandatory reporters. So that's kind of the world that we were living in. And, faculty had issues on the faculty side with free speech and whether they'd fall under the purview of Title IX if they said the wrong thing. And then also this mandatory reporting thing, making, really violating confidences with their students, changing the relationship with their students. And then finally, I think, the thing that came out most in the news and were the subject of the lawsuits were how the students themselves were affected. So you started seeing lawsuits on both sides, on the side of you didn't do enough for the complainant and on the side of you did too much for the defendant. And it was a very messy terrain for college bureaucrats to navigate.
Yeah. So one of the things that emerged out of this was when you said it was the responsibility was placed on faculty, these panels were formed, right? In most colleges that adjudicated all these cases of sexual assault. And on those panels sat professors of English and philosophy and Russian literature and the English novel. And since there is almost never any evidence in these cases, right? All the evidence.
There's not often direct evidence.
Direct evidence. Sorry. So the only evidence generally is the testimony of the complainant, right, and the defendant.
Well, and corroborating evidence is huge in these cases. Like, who did they tell? Right. When did they tell it? Is there a picture? Yeah.
But I mean, I was at Occidental College when this was all happening, and Occidental College was like an epicenter of this sexual assault. I'm going to call it hysteria. And couple of the faculty, or one of the faculty who was leading it there is actually in your book, Caroline Heldman, who became like a national sort of leader of this movement to eradicate rapists from college campuses. When I was there, I talked to several faculty who sat on these panels making judgments on whether some boy raped some girl. And it was chilling. It was chilling because they said that the only way that they could make any determination at all was to ask about the sexual histories of the two people. But usually it was just about the guy in that case. So it was a professor of, geology interrogating some 19-year-old sophomore about his sexual history. And from that, they would determine whether or not he should be expelled or punished. I mean, talk about a kangaroo court. And that became the norm, I think, on college campuses. I know it was the norm. I know that's what was done in all the colleges where I've been a faculty. So that was just one of the most, I mean, that was sort of, to me, the most grotesque consequence of the Dear Colleague letter of 2011. I mean, the colleges took that to mean that, we must have these panels made up of professors who don't know anything, asking their own students about their own sexual histories. I mean, that's pretty gross.
It's interesting because, one of the things that's been incorporated into the new Title IX regulations, which, are automatically hated by many because they were promulgated by Betsy DeVos. But I actually think they're a mixed bag, and there are some good things about it. But one thing she preserves is a rape shield law, right? So the rape shield law doesn't allow you to ask about the complainant's sexual history. It'll be interesting to see. I have to read it more carefully, but does that also apply to the respondent's sexual history? And I know that in some schools it applied to both. Like, you weren't allowed to ask about anybody's sexual history.
What do you think about that? I think asking about sexual history should not be allowed at all in these cases.
I think as a general rule, it shouldn't be allowed. But let me just back up. I'm not sure that I would just blame sort of feminist professors for the campus rape moment.
Okay.
I mean, it really was. I mean, you had Fox News saying, campus predators abound, every parent's nightmare. I mean, this was something that really, I have it. I have a headline, right? This is something that I think now with, a lot of the reverse Title IX lawsuits with a lot of the boys who've been mistreated, the politics of it have a little bit split left, right. But before, I mean, everybody was against rapists. Everybody loved, to panic about and worry about predators and be against predators. And that just, caught on. And it caught on in a moment where I think there was abundant feminist energy bubbling up, like political energy. Students were really political then, and they're still political today. And that sort of was a way to channel politics. It was a weird moment of sort of, I thought, channeling politics in a very sort of illiberal way, in that it was like anti-due process and anti-sex. Sexual liberation is at the same time, right. But it kind of happened like that. So I wouldn't completely put the blame on the faculty or even the college bureaucracy, because I personally know Title IX people who just like hate their lives, right? Like they hate this world they find themselves in, where it's like, I'm damned if I do, I'm damned if I don't. I'm trying to be fair, but the government tells me this. My boss tells me that. The students are saying this. I can't drop a case or I'll get sued. I can't pursue a case or I'll get sued, right? So that also had happened, right? But to your rape shield point, so what the rape shield laws have done for many, many years is they've said that the victim or complainant in a criminal rape case, and then also in civil, but just with the criminal, you can't ask about their sexual history. That's just a blanket prohibition. Right. And most of them have an exception for unless it's constitutionally required. Well, when is it constitutionally required, right? So an example of when it's constitutionally required is, what if you had a really good case, texts and everything, that the complainant had fabricated the rape to cover up an affair when the husband found out, or the boyfriend found out. Well, you would really need to talk about both the affair and the prior sexual relationship with the boyfriend, right, in order to defend. So that might be a case where the rape shield law should at least allow in, under the constitutional catch-all, that sexual history. So the idea was, don't just say, oh, this woman has sex with everybody, and therefore she had sex with this guy. That doesn't make sense. It's prejudicial, and we can't let that in. I don't think anybody's saying that should be let in. I think where the battles are being fought is when the prior sexual act is actually a part of the defendant's case, right? Like that is the crux of his case. And then you keep that out and portray this in a false light. Like, oh, she's saying he raped her, but she has no motive to fabricate. And the reason the jury is allowed to think that is you haven't allowed them to see the backstory that the defendant was trying to put forward. Another area where it gets really tricky is if the complainant is a sex worker, and that, those are really horrific cases, tricky cases. And I'm not, I'm less favorable into allowing the sex work evidence in just because there is this huge prejudice against sex workers. But if the defendant's going to argue, this was a transaction that went bad, she demanded more money afterwards, I didn't give her money, and she's claiming rape, do you get to bring in this history that's going to prejudice the jury? So, I think there are fair arguments on either side. But what I have seen is that most feminist activists want the strictest rape shield laws, like nothing comes in, under the theory that if you give judges a constitutional catch-all, they're so sexist, they're just going to be letting in all kinds of sexual evidence and putting the victim on trial. From my research, I haven't found that. I mean, I think judges probably do have sexist prejudices, but they have even bigger prejudices. The bigger prejudice is the prejudice against the guy sitting in the defendant chair charged with sexual misconduct.
Yes.
That's their biggest prejudice.
Yes.
And everybody who's representing him.
Yes.
And giving the defense a leg up, right? And not helping prosecutors. Those are the prejudices that I experience.
Right.
So I just fundamentally have a different view, and maybe it's shaped by the fact that I was a public defender.
Great.
But again, another thing you hear from feminists is nobody ever convicts anybody of rape at trial. Well, actually, no. 98% of rape trials end in convictions.
Oh, really?
The same as all felony violent trials. You bring a guy sitting at defense chair in front of a jury. You have the police come in. You have all the prosecutors in their suits and everybody saying this guy did it and it's a horrible sex crime. Chances are that guy's going to get convicted.
Wow.
Right. And but what we'll see in the news is when the sort of outlier egregious cases. It's true on both sides, though. We'll see the outlier egregious cases of false conviction, and we'll see the outlier egregious cases of lack of conviction. That's just the way media works. But the reality of it is no. And so since the 90s, reformers have speculated that that's not where the prejudice comes in. It's not a trial level prejudice. So all these trial level reforms are, kind of out of place. It's arresting, charging, and prosecuting prejudice, which is plausible. But from my research, prosecutors actually brought felony rape cases more often than felony non-sexual assault cases and like burglary cases. So, their dismissal rate was lower. They brought more of those cases to trial. So I didn't see it in the statistics on the prosecutors level, but it's plausible that it's on the police level, that they're dropping too many cases.
So if you're seeing any sexism in the system, you're seeing it against men.
I don't know that I would say it's against men. I think it's against sex offenders. And I think, let me put it this way. Whether you say there's sexism in the criminal justice system against men or for women, I guess they're the same thing. The way I put it is, there's massive benign discrimination toward women in the criminal justice system. They tend to have more charges dropped, be charged with lesser crimes, and receive more favorable plea agreements and go to jail for a shorter amount of time.
Okay.
So whether that's discrimination against men or benign favoritism towards women.
So as defendants, you mean?
As defendants,
Gotcha.
Absolutely. So that's an interesting thing. And what we're seeing over time is that this, what I call benign sort of discrimination towards women in the criminal justice system is starting to fade. Yeah. And it especially fades along racial axes. Like court actors are way more likely to treat black women more like they treat male defendants, give them the harsher things.
Yep.
But all women, I mean, women are the fastest growing segment of the prison population.
That's right.
That is eroding. So I don't know, like, should we be out there as feminists celebrating, yay, women equally get to go to jail in the carceral state?
Right. Yeah. Well, that would be that would be feminist equality, right?
It would be a form of equality. And I could imagine that.
So with the
people would start
draft,
to- Right.
yeah. So I mean, that's what the proponents of the ERA were calling for. Things like this, right? Everything's equal, including all the really bad stuff that only men have done in the past.
Yeah, I mean, and there's an argument in favor of that, I suppose, if you think
Sure.
that, your highest goal is equal dignity, and you believe that dignity comes from punishment, getting the crime it deserves, then yeah, women's crimes should get the punishment they deserve, and then recognize their dignity. I just don't personally think punishment is a dignified thing in the world right now.
Right. So you mentioned your career as a public defender.
Right.
So what I want to do now, I want to talk about your history, and then I want to talk about the history of the topic we're on right now. So you were born and raised in Miami, is that right?
Yeah.
Okay.
Yes, I was.
And you describe yourself as a feminist in the book. And when did you start doing that?
Being feminist?
Yeah.
I think from as far back as I can remember, I always felt, it would be really unfair. This is what I would think to myself. It'd be really unfair if I wanted to go get a job and work and have a great career, but what if I also wanted kids? I couldn't do those things, and men get to do those things, and it's not fair. That's sort of when it started.
Okay.
I think it wasn't fair that men were allowed to have a career and kids, and women who wanted a career couldn't have kids. That was the main thing when I was like 9 that I thought feminism was. And then I started getting really into, I think this is, we talked about being punk rockers, but when I was a punk rocker, I started getting into this idea of like beauty oppression. Women, they have to wear high heels, and just all the sort of compulsory things that women had to do to be attractive and,
right.
Have self-esteem. And that really bothered me too. And so, I was in high school when, the first Hooters was built, and I got really annoyed at that, objectification of women. So This was always my thing. And part of it was always that proof of women's status in all these ways that I thought it could affect my life. Proof of women's lower class status was their susceptibility to life-ruining rape.
Yeah.
That was hammered into me very early on from some of my friends in junior high school, talking to me about one of our mutual friends who was just ruined in life because she had been raped, right? And so this was just this fear of being ruined in life because of it. So that's my feminist side. It's just always been there.
Okay. So this is, you're talking about high school as a teenager. You have these ideas, right?
Yes.
Okay.
Yes.
And then you go to UC Berkeley.
Yes.
Okay.
Yeah, I did.
And what happened to your ideas there?
Well, I didn't really deal too much with feminism when I was at UC Berkeley. I studied metaphysical philosophy.
Yeah.
So that was hard enough. Trying to figure out the third antinomy of pure reason. Right. Right? That's whether there's a cause that's absolutely necessary. But okay. So, I just felt the same things. I had this feeling that, women had like sort of compulsory motherhood and compulsory like beauty and compulsory ways they had to be, and were disempowered in those ways. And I still held on to these beliefs about gender violence throughout the whole thing. They weren't informed by taking any women's studies courses. They were just informed by life's experience.
Okay.
And then, I went and I waited tables for a couple years. And so then I went to law school, and in law school, I had this half of myself that had this life's experience, accumulated folk knowledge of how women were unequal and why. Mm-hmm. But it wasn't particularly academic. I read Simone de Beauvoir, but, and I read The Feminine Mystique, but nobody would say going into law school, I was some, expert on feminist legal theory, because I just wasn't. And I probably wasn't even one after law school.
So Harvard Law, where you went, became I guess shortly after you got there, or about the time you got there, kind of the center of the anti-carceral feminist school of thought, right?
When I went there, no.
No, oh really? Oh, it was later.
It was later.
Okay,
Yes,
but you were sort of
it was many years later because I graduated in '97.
okay.
It
But
was
there
many
weren't
years
but there
later.
weren't there some of your classmates there who were part of this, who ended up becoming sort of the anti-carceral feminist leaders?
So the anti-carceral feminist, I guess, intellectual leader at Harvard Law would have been Janet Halley.
Yep.
And at the time, she was, I think she had just, when I graduated, she had just published Split Decisions.
Mm-hmm.
But I didn't have her for classes. She didn't, I believe, teach criminal law. And most of these discussions came up when we discussed rape. And I was actually taught rape by Alan Dershowitz, who who I was a research assistant who I was working for at the time. And
is Dershowitz pro-rape or anti-rape?
well, I would say that he's anti-rape in the sense that he, I don't think he likes rape. That would be not how I would see him.
Even Alan Dershowitz doesn't like rape. That's how bad it is.
Yes, I mean, other people thought he was pro. You know, the biggest complaint that I heard about him afterwards, I thought he taught rape really well. He was very into the subject of what does it mean to rape? How do these intents work when you're dealing with consent, right? What does affirmative consent mean? I found it all very interesting. But people, I later heard, really complain that he used rape as an example in too many things, brought it up too much, and was too glib about it. I mean, that wasn't my experience. I can't really speak to other people's experience, but I know friends of mine who aren't carceral feminists or anything, they're public defenders, who really didn't like the way he taught rape. But I just remember in my big section, people were kind of debating, and the one person who was really against affirmative consent, which is what people know as the yes means yes rule, sort of loosely. One person who was really against it was a kind of sex positive, radical feminist with this like short haircut, you know, and she was like, you're going to take the sexy out of sex. And she was probably the most vocal person that day. Yeah. And I was like, wow, you know, but that existed. But other than that, I don't remember in '97 there being either a really anti-rape activist group at Harvard or sort of an anti-carceral feminism activist group at Harvard. It was pretty quiet, you know, in terms of those things, I think, back then, and really got ignited later around 2010.
Okay. So then after Harvard Law, you became a public defender, is that right? Pretty soon.
Yeah, I was a federal court clerk for a while, but then I became a public defender.
And that was in Washington, D.C.?
Correct.
And so, and that's your book starts with a story about you as a public defender in a case that, I mean, it seems to really sort of encapsulate a lot of what happens to people in the system. And why don't you just tell that story about Jamal?
Yeah. So just to back up a little bit, I talked a little about my feminist side, but I'll spare you all the details, but I always had a really civil libertarian side too. So that's why I became a public defender.
Okay.
But when I was in law school, it was quiet, like this feminism, public defender stuff. So I always felt really conflicted. I'm like, okay, I'm going to be a public defender. I know what to say about all these people who say, how could you defend those people? These guys are murderers. And I have my stock answer to them. But I really didn't know what to say to people who said, how could you defend batterers and rapists? I mean, I was so in that mindset that batterers and rapists were just these monstrous worst of the worst that I was more worried about defending some guy who got like a misdemeanor DV assault than defending a murderer. Like that was my headspace. Wow. I think that was a lot of, feminist defense attorneys' headspace back then. It's really? Like, wow, I can defend all people who other people say do horrible stuff, but I could never defend, a gender crime. That would just be the worst and a betrayal of everything I believe. So I kind of had that dilemma. Then I go into the system. And this is where Jamal and Brittany come in. Washington, D.C. had the second specialized domestic violence court in the nation. And that means a set of reforms that were pushed through by feminists where and other activists, where judges were specially trained to take domestic violence seriously, which could be good or bad. Bad when they were threatening to lock you up for cross-examining, a witness, right? Like your questions were to mean you're going to get locked up, Gruber. Like that wasn't good. But sometimes in them being, sensitive to all the people involved. No drop policies on the part of the prosecution, right? So you've got to bring these cases forward whenever you can. Don't drop them out because you think the evidence is weak. And a set of other things like holding our clients in custody until they could serve restraining orders. So this came with a whole bunch of set of reforms. And so who were the people caught up in these reforms? Well, what I noticed, it was a lot of poor people of color and a lot of immigrants and a lot of women who themselves were facing prosecution for neglect charges or other things, fines and fees. And so the story I tell about Jamal is not a spectacular story. It's basically a story where he and his girlfriend were poor. They lived in a project called Lincoln Heights. And amazingly, he had made it to 19 without any record, which I thought was pretty great. And they both were there in court for the first day of, the hearing, pretrial hearing. And they both looked really cute. I mean, they looked like Disney show people. And so,
But why were they there? Why were they there?
They were there because he threw a plate at her
Right.
and hit her, according to the police report.
Right.
Not like punched her in the face. It just said a hit, right? And so she comes up to me and she said, look, I don't want to be here, right? But the other lady, I assume the other lady was the domestic violence advocate, told me I have to be here, right? And then she's like, what if I don't show up? What if I'm like a no-show? What's going to happen, right? Will they drop the case? I just remember that so clearly because the answer would have been probably yes. They could go forward with some, but it's a pretty good bet that if the complaining witness doesn't show up, they're going to drop it. And if you asked any public defender back then, they'd have had so many complainants, where their family members were involved in the crime, whatever the crime was. Right. Ask them about not showing up. And that puts you in a really tough position because you certainly don't want to be charged with obstruction of justice. So we just tell the victims, we can't tell you what to do. I don't know that I would have been in trouble for saying, okay, this is what generally happens, but I wasn't gonna go there. So then the domestic violence advocate comes up, and I just remembered her very clearly because she was a student. She was a wealthy student, big diamond ring, blonde hair, designer bag, all the whole shebang. And she was like, what are you doing talking to my victim? I was like, oh my God, she's your victim. I said, well, she came up to me and da-da-da. She said, well, I'm sure she did. And it's true. When you talk to domestic violence advocates, they really did think that defenders were extensions of the abusers who were just prolonging the abuse to the victim. So they came from a certain mindset. They also pretty widely believed that defenders would do really unethical things to sabotage cases. So they were really skeptical of defense attorneys. Well, to make a long story short, she forces Brittany into this civil protection order, which means that Jamal for a year has to stay away from Brittany and their new baby. So he's supposed to move out of the house and have no contact. They never did that. They never had no contact. Brittany eventually doesn't show up for trial, but the prosecution was able at that time to go forward on the hearsay evidence, the 911 call, and the police's report. And so he ends up taking a plea. And the plea is for deferred sentencing, which he fails because he can't afford to pay for the 27 anger management and domestic violence classes they want him to appear for. The couple loses their eligibility for public housing because he never moved out. They both were violating the protection order. And you can't have somebody with a DV conviction living in your household. So anyway, it was just, a story of everything that all these little punitive, things made in the name of feminism and protecting women can add up to make this, poor couple of color and their little baby just in the worst position. I even saw worse than that. So you would have these immigrant defendants come in who even had green cards, but then they would plead guilty for a deferred sentencing, thinking that if it wasn't a conviction, they wouldn't be eligible for deportation.
Mm.
But the guilty plea alone made them eligible for deportation.
Mm-hmm.
So what you ended up having was a non-native English speaking woman calling the police because she wants some help in this situation. And then she triggers this penal machine that ends up deporting the spouse.
Oh.
And to make matters worse, I'll just say one more thing. And this is what I'm experiencing as a feminist.
Mm.
You have sometimes some people that say, hey, immigrant woman, I can get you, well, this was pre-Trump when it's very hard to get anybody a visa now, but I can get you a visa on the basis of being a battered woman, but you have to tell me that your spouse is battering you, right? And so all of this was a piece of me seeing day after day this specialized, enlightened, progressive left domestic violence system being a revolving carceral door that it didn't feel to me was helping many people. And that was very early on in the process. And my original Feminist War on Crime was an article I wrote in 2006 about practicing in that court. And it just led me to think, what have I been missing this whole time, where I was so convinced that rape and domestic violence were these horrible and most pressing markers of female subordination, that it led me, an incarceration critic, to embrace this idea that prosecution would be the solution to the problem. How was that so powerful in my feminist folk knowledge formation?
What
so
do you
that
think?
Really let me
What's your explanation for that? Why were you thinking that way as a critic of incarceration? What was the culture that got into you?
I think the culture that got into me was what I now that I've studied the feminist literature, was pretty close to what second wave, a lot of second wave mainstream feminist literature, and even not mainstream, on the dominant sort of radical feminist side, were saying, which is that violence and sexual oppression are the markers of women's subordinated status. So you can take away everything else, right? Like women's subordinated status has always been overdetermined, but you could take away everything else. You could take away work. You could take away, the distribution of wealth. You could take away child rearing responsibilities. What subordinates women is gender crime. And how we know that, and sex, right? Like, and a lot of sex that we're going to put in the category of gender crime. That is the marker of women's unequal status.
Well, okay, so I would, devil's advocate.
Yeah.
Actually, not really, because I think this is a legitimate claim. I mean, to me, sort of the foundation of a lot of these feminist arguments is essentially the fact of men's physical superiority over women, right? I think much of this stems from that, and sort of the layperson's response to you or critics of carceral feminism would be, well, but men can do anything they want with women at any time physically. Women are essentially helpless if a man wants to rape them or hurt them, right? I mean, how do you respond to that?
So the argument would be that the dominant feminists are right, that this is the marker of women's subordination.
Yeah, I mean, well, I'm just saying that's the argument, isn't it? That's what they're basing it on. That's the basis of their argument. Isn't it?
I mean, they make it even more. Well, there's definitely a strain running through that, right? Like that this is a biological and not a socially constructed phenomenon.
Yeah.
And their strain running through it is even more graphic than that. It is the way that the penis and the vagina are formed, right? So
Catherine McKinnon,
Andrea Dworkin,
Dworkin, all heterosexual sex is rape.
Right. Yeah. Well, okay. I mean, I think that's kind of. I mean, she more said in conditions of domination, it's difficult to tell
No, but I'm just okay. But
ordinary everyday sex from
yeah,
women.
I think that's of course just a ridiculous construction. But I don't think it's a ridiculous construction to say that, even though I oppose it, I don't think it's a ridiculous construction to say that women, in general, of course, are less strong. They are physically inferior to men, and therefore need special protections.
Well, I would not say women are physically inferior to men. I would say we're physically different because you might run faster, but I might run more gracefully.
Well, different. I know. I meant in terms of strength, in terms of what's relevant in rape, right? Relevant in rape, not relevant in sports.
I suppose. I mean, I suppose that there is a biological argument to be made that
Mhm.
women fear rape and are thereby
Yeah.
controlled by the fear of rape and thereby oppressed by the fear of rape because of the physical aspect. I think
Yeah.
that's true.
Yeah.
Um, but I don't know. I don't know because a lot of this feminist work happened in the date rape space
Mm-hmm.
where the physicality of it all is not as prevalent
True.
as in the stranger rape case.
That's very. That's very
I think
true.
everybody and their brother was on board. If you bonk somebody over the head and drag him into the bushes, that's a rape. In
Right.
fact, so much so that the penalties for
Oh.
those kind of crimes are just like outlandishly high.
Oh yeah.
you know
Right.
and then where it got tricky was, well, we don't have this vocabulary for what's going on in the 70s, which is a lot of date sex, and a lot of this date sex is like
Mm.
and can we use now that rape vocabulary for the date rape sex? So it wasn't so much as overpowering. I mean, they used force, right? Like the word force.
Mm-hmm.
But especially if you factor in that a lot of these couplings will be male bigger, female smaller, like
Mm-hmm.
not always,
Mm-hmm.
we need
Mm-hmm.
male stronger. But like, does that fact itself mean anytime sex occurs, it's in the context of force because of this pre-existing idea that men
Right.
have this power? So yes, I think for the dominance feminists, they would say yes. They would absolutely say yes. I think for them, it was a combination of women's unequal bargaining power in society and men's physical form
Mm-hmm.
that made it much easier to call a lot of sex rape,
Mm-hmm.
right? And so what they wanted to do was to have these really broadened coercion standards
Mm-hmm.
where you could find sex to be criminally coerced in a lot of scenarios, not just like a bonk them over the head, drag them into the bushes. So that was a very dominant feminist strain. They lost because the liberal feminists wanted consent. And they got it. And right now, consent is the name of the game. And that was a very liberal bargaining way to look at, and kind of non-feminist, right? When you assume people are equal bargainers, you're just taking away patriarchy. You're just like shushing it away.
Yeah.
So, but that kind of won the day.
Yeah. I'm going to continue taking this devil's advocate position,
Yeah.
even though it is totally contrary to the way I think.
Yeah, good.
I am famously anti-essentialist, infamously even, but I want to just try to inhabit the mind of your opponents here,
Yes.
and do it fairly. So, I mean, I'm gonna use my words in a postmodern way that makes it clear of essentialism. So the people that we call women, right, in general and overwhelmingly, are eternally, most likely, or at least so far have been, as I said, physically less strong and less able to resist violence. And therefore they are in an eternally vulnerable position vis-a-vis men. Therefore, and has been a feminist argument for a couple of centuries now, which led to what was called protective legislation, right? That were, certain carve outs, women weren't allowed to work a certain number of hours in factories because they were, not physically able to, right? That's a big controversy in feminist history. But I mean, the people we call women, right, are in fact, in general and overwhelmingly, physically less strong and smaller. And it is true that if a man wants to do harm to a woman, usually he can without someone stopping him. Now, the someone stopping him is usually not there, the feminist argument goes, which means that we need the state to be the person there stopping him. And this is an eternal condition if, again, we agree that those people we define as women, we call women, are physically vulnerable, then why shouldn't we have special laws with special protections for them?
Well, okay. I mean, even if that sort of describes how sex occurs, that women are vulnerable and men regularly force themselves on them such that the state needs to step in. I mean, even if that were true, the state has stepped in.
Yes.
They've stepped in from time immemorial, right? I mean, the sex has been so highly regulated. And so force has always been on the table. So if somebody uses their superior strength and forces somebody to have sex that they don't want, I don't think you're going to get an argument from anyone that shouldn't be a crime. Where you get the argument, and where I would argue, is presuming things about women like frozen fright and lack of ability to negotiate. And that the man therefore has to go through a series of checklists.
Right.
So there's a lot of sunlight in between don't force someone to have sex, and you must do a series of checklists to make sure that no matter what she says, she really wants the sex because maybe she's frozen in fright and maybe she's in tonic immobility, right? Like there's a ton of sunlight in between those two things.
Right.
So in terms of the tonic immobility, and just for people who don't know what that is, tonic immobility, actually my dad discovered it in sharks, is when, for certain animals, and sharks and alligators are those animals, when you turn them over on their backs, they go into such a state of catatonia from stress, it's a stress reaction, that you can do things like my dad used to track sharks, he'd place transmitters in them. So the idea is this in the feminist literature, which is fairly, which I just find anti-feminist in ways, but the idea is this. Here's why we need a yes means yes sort of performative standard, like, which basically says guy or gal, but mostly guy, you can't have sex unless you make sure that the other person is affirmatively expressing agreement, right? So the counter to that is naturally, well, wait a second, right? Like, can't we just assume that if somebody's making out with us and kissing and we're right there and it's escalating to sex, that they're agreeing? And the answer to that is no.
Right.
Because that person might be in tonic immobility and frozen in fright and feel undisclosed fear.
What's the term? What's the tonic immobility?
Tonic immobility.
Tonic, like as in tonic water? Like how?
Catatonia.
Like catatonic.
Yes.
Catatonic immobility.
Yes.
Oh, wow. Oh, they're actually claiming that women go into that state.
Into some state of that, right? Some state where they're too scared to really express what they feel. So this performance that we're asking sex proponents to go through is necessary, because we're going to presume that a lot of women are making out and just going along and kind of doing things because they're in this state of fear. And it's based on these kind of weird 1970s studies of victims who, in the face of life threat, get very passive. Well, I think if somebody's holding a gun to my head, and I'm kissing them because they're saying kiss me, I think you could pretty much assume I'm in a state of fear.
Right.
But if somebody's holding a gun to my head, you don't need affirmative consent.
Right.
So the problem I have with affirmative consent is not the argument that women never go into fear. Yes, women faced with very aggressive life threat, blah, 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 they can go into a state of panic and fear, but you got the person dead to rights. He used a ton of force. It's how that becomes an argument for affirmative consent. Because affirmative consent is only necessary in a normal situation where you just want to make sure everything's hunky-dory. So I want to know which women in a normal making out situation are in this frozen fright. It's very hard to imagine, right?
Yeah.
And so one thing I've heard in response is, well, they might have had a past undisclosed trauma. And so now whenever we have sex, we have to walk around assuming the other person has a past undisclosed trauma. And that's what the law is based on, that everybody has past undisclosed sexual trauma so that they are out of the ordinary sexual actors. And I just don't believe it. Most people come together, they couple, they have sex, they read the signals, and it's fine. Yeah. Where it falls apart, I agree, it's tricky, and we've got to navigate our way through it. But like constructing this world of traumatized women walking around going into tonic immobility, I just don't think that's feminist.
Yeah. So it constructs women as eternally, not just vulnerable, but eternally wounded children, is it not?
Right, like vulnerable, I don't have a problem on you. A problem of you could define vulnerable in a very sophisticated way and look at different people's moving vulnerabilities at different points in time and where our vulnerabilities converge, and you can theorize that.
Mm-hmm.
Where I think everything goes wrong is that you have this aspirational standard, and I'm going to put it in quotes because you'll find a lot of people, and at first, even as a scholar, at first I was like, yeah, I think affirmative consent is good as an aspirational standard. Why wouldn't we want to ask our partners if we want to have sex? Like, why wouldn't we want to do that? But my views on that has changed, and I'll say why in a second. But even if you agree, okay, this is like the right thing to do, translating the right thing to do is into we will put people in jail for not doing it is a hard thing. So then you have to come up with a justification of how people who they're having perfectly fine sex, it just doesn't have an affirmative consent performance in like
Right.
what they did wrong. You have to have an account of why that's wrong. And it's in that accounting that you find all these like wacky arguments like, well, it just is wrong not to ask people before you do stuff. I'm like,
Okay.
I don't ask people before I do all kinds of things depending on my relationship with them, right?
Okay. Yeah.
Or you get, it's like a speed limit, right? Like it's like we're punishing you for taking the risk.
Right.
Well, what kind of risk are we taking? So that's where you get all these arguments. And so, I, in researching it for the book especially, have come to feel that we should do a heck of a lot more research on how people actually have sex and what's actually okay and not okay to them, and construct rules around that instead of starting out with the ideal and then trying to fill in the criminal part.
Nice.
And so one of the things that led me to that is this suite of apps that they were marketing to college campuses for their students to buy and like give it to them during orientation. And it was called the We Consent app. Have you heard of that?
I remember, yeah.
So right, like so when you're going to have sex, like that you point your camera and the two-way video does the consent colloquy that you have to have, and then it encrypts it, and it goes to the cloud, an encrypted cloud where only the police or some campus tribunal can get at it if there's a dispute. So you don't even have property in it. And then the part that really, kind of freaked me out about this is the second half of that app suite is a what about no. And they specifically market the what about no app to women. And when you feel uncomfortable or about to be frozen in fright, right? Like when you feel uncomfortable, you show this picture, you hit the app and show it to, the other person. And it's a picture of a white cop. It's a video of a white cop in a police hat waggling his finger and saying, no, 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 no. Wow. And so that, I'm like, if that's the world that affirmative consent hath wrought, maybe it's not even aspirational.
Wow. Okay. So let's do the deep history of all this.
Okay.
Because the first few chapters of your book go all the way back to the 19th century and take it forward from there. So everyone knows, Aya, that in the 19th century and well into the 20th century, that rape laws were hardly enforced, that cops looked the other way, that they didn't take women seriously who were raped, that judges didn't take seriously women's complaints, that women had no recourse generally if they were raped, and it was a thoroughly patriarchal system that was rape culture. We all know that, don't we?
Right.
Now, I'm going to admit something. I told you at the beginning of this that I'm a U.S. historian who has studied, written, and taught about these issues for 2 decades. That, what I just said, was not too far from what I thought. I sort of assumed, and I don't know why, because it was dumb of me, but I kind of assumed that, that until sort of modern feminism comes around. My mother, by the way, was an anti-rape activist in the 1960s. But I assumed that until modern feminism comes around, that this is what happened to women who were raped in the criminal justice system. Your book turns that completely upside down, and I wanted to thank you for that, for changing, for correcting what I thought. So why don't you talk about that? The 19th century was very different than popular conceptions, and certainly feminist conceptions of what used to go on.
Oh, absolutely. And I think others have written on it, but they write on it a lot in the context of doing histories of like Frances Willard and the temperance, movement.
Yeah. Yeah.
And they say, well, this was kind of like an anti-vice movement. They don't talk about rape. So I too believe the linear story, right? Which was throughout time, men have had a male sexual license and have been able to freely rape women.
Right.
And there's been no significant challenge to it. And all the boys raping in the college campuses now are just the continuation of that male privilege.
Right.
And so change is long overdue. That's the stock narrative.
Yep.
When you go back in time, I don't think it is clear that men writ large had a sexual privilege, a sexual license. The thing that had a sexual privilege that is very clear is marriage. Marriage had a sexual privilege, right? So many of these laws were meant, yes, maybe to punish rapists and maybe to do this and that, but they were really meant to confine sex into marriage and make sure that it didn't spill out of that. And so within that, you had rape offenses. You also had adultery and fornication offenses. And adultery and fornication offenses could be brought against men, but they also could be brought against women.
Very often, in fact.
Very often. And
yes.
One of the defenses that women had was rape, right? Okay. So then you have these archaic rape rules, which are awful. I mean, today we hear them, we think awful. So you couldn't claim rape unless you had corroboration, right? What did corroboration have to be? An eyewitness? Well, nobody's going to eyewitness a rape. So typically corroboration was you had to be beat. You had to be beaten in order to have the rape corroboration. Then you needed to make a fresh complaint. If it was a few weeks old, forget it. You couldn't bring it in. Promiscuity was, a defense, and you needed to show that you resisted to the utmost. So we look at all these and we go, oh my God, the past law was so sexist it hated women. Well, one of the readings on this, like, hard to prove rape was that it was a way to make sure that women couldn't use a rape claim as a defense in fornication cases. So it was really an anti-defendant in these, marital sex policing set of rules. Now, did it also have the effect, these legal rules, of privileging certain men who were accused of rape? Yeah, probably it did. But on the other hand, what you see in history is juries and prosecutors had no problem prosecuting certain men for rape.
Right.
So low-class men, working men, men who were known as slovenly drunkards in the neighborhood, men who used violence, men who raped children, and, of course, infamously Black men.
Yeah.
So what you see then is this policing of sex that's quite robust, and licensing certain people to engage in sex and rape, and other people not to. So it's not this linear story of like rape is never taken seriously. We have a massive sort of sex policing system going on in the late 18th and late 1800s and early 1900s.
Right. Yeah. So yeah, you chalk this up in part to Puritanism, which I thought was brilliant and completely correct. And also Victorianism. So, the 19th century is kind of when Puritanism is kind of morphing into Victorianism. So, well, people misunderstand Puritanism in so many ways. And one of them is that they often think it only afflicts women or affects women. But Puritanism in its sexual components, Puritans are anti-sex, period, outside of marriage. They don't care who's having it. They don't like it. Right.
Well, it's interesting. So when I was reading about the Puritans, because I got really fascinated by this article I had read from David Bryden and Erica Mador in a law review symposium that I organized on sex law, he wrote about these Puritans being some of the toughest on rape and having the lowest rates of rape and being really kind and gentle to the rape complainants, the victims, because they were so anti-sex. So then I started reading about Puritans. And it's not just that they were anti-sex, they actually were incredibly pro-sex within marriage.
Yeah.
Yes, they just thought it was like the duty of the husband. So if the husband was going to be like a modern Al Bundy and never have sex, like he wouldn't be doing his husbandly duty to give the wife pleasure. I mean, that's kind of a progressive, view of sex, so long as it's confined to marriage.
Right.
So what's interesting is they were also a highly patriarchal society with extreme oppression of women, but they were also an incredibly rape intolerant society.
This is what people don't understand. Right.
Yeah. So this idea that patriarchy and rape tolerance is the key, it's not true. I mean, why did rape remain a capital offense for so long? After most felonies, it started out with all felonies being capital offenses. Well, rape remained a capital offense so long because of these ideas of women's ruination and their not being fit to be, husband's property. And that's why in 1977, when the Supreme Court was reviewing the first case to challenge the death penalty for rape of an adult woman, Ruth Bader Ginsburg wrote an amicus brief on behalf of the ACLU. And her position was that the feminist position on rape in this situation is an anti-punitive position, because giving the death penalty for rape is located in these notions of women as property of men, in women's ruination, and also, even more disturbingly, rooted in the Reconstruction era South and accusations against Black men. So given this loaded history of this rape punishment, the feminist position should be anti-carceral in this space.
Right. So then the Victorians come along and they have this idea that women are naturally uninterested, or certainly less interested in sex than men, that a good woman is a pure woman. And so what you show in your book is that they punished rapists, but they also were not interested terribly in punishing rapists who had raped women who were promiscuous, who were not pure women, right? And that's where the sort of traditional feminist notions about this history actually make sense, right? Or that actually comport with the evidence, right?
Right. So it was very interesting because when you look at the temperance movement leaders, Susan B. Anthony, Frances Willard, they really did have, sort of this regressive streak. And this is the one that they usually come under fire from feminists and more liberal people of, middle class marriage norms, productive means of work within marriage, sort of sexless and God-fearing. But there was a real part of that was actually feminist. So I have one of these speeches from Susan B. Anthony, her home protection speech. And she really does talk about a feminist problem, which was that some of the most marginalized women were stuck in the home while their husband laborers went out and they partied all night and they got drunk, and they would be getting beat up by drunkards, right? So all the feminists were lamenting the problem of the drunkard's wife, right? And then if she went out of the home to work, well, women were just given the worst jobs, terrible work conditions, menial labor, and possibly prostitution. So Susan B. Anthony talked about this double bind that women were in, where if they stayed in the home, they were subject to beating and sex being forced on them, basically rape, right? She called it lust, but it was basically rape. And if they went outside of the home, they were subject to these really horrible capitalist, and sexist working conditions. So there was a real liberal strain in there too. But, what came out of what was kind of a mixed bag of morality and feminism was more the morality part, right? So what were the laws that were championed that came out of this feminist movement? Right. Well, they weren't the twin vices of violence and capitalism, right? They were the twin vices of drinking and sex.
Yes.
Right? So then, and it was an interesting move to say, we really care about drunk wife beaters, but we're not going to throw them in jail. We're just going to make sure nobody drinks.
Right.
It was an interesting move, because these days would be throw the individual in jail. But I think what the feminists recognized then, that the DV activists sometimes don't even recognize now, is that the women were tethered to the men. You threw the men in jail and he lost his job, she'd be worse off. right? So let's do a structural solution. But their structural solution was like, no liquor.
Prohibition.
Right, but at least they did it for everybody.
Right.
Like they did it for everybody.
Right. So that's one legal success for feminists in attacking rape was they went right after alcohol, right? And what they got was prohibition out of it, which did what to mass incarceration? Created it.
Right. Well, and also probably, created a lot of underground scenarios where people were being raped, but because they were in an underground market, they couldn't, so who knows what it did to rape too, right?
Yeah, exactly.
The criminality that came up in the wake of it. So they did the alcohol prohibition. And then another thing they did was, vice laws, obviously, but also rape laws. And these rape laws were also an interesting bag. And they were a huge victory. Right. So by the time Frances Willard was done with her movement to raise the age of consent, every jurisdiction had raised it to between 16 and 18, whereas before it had ranged from 0 to 10. Right. And whenever I tell this to people, they say 10. Oh my God. Right. Like, that's horrible. But then I asked them, I'm like, well, do you like statutory rape prosecutions? And most, very liberal progressive people are like, oh, they're terrible. And, I'm like, well, that's where they came from.
That's right.
Because we're not talking about criminalizing forcible sex or unconsensual sex between 18-year-olds or 17-year-olds, I should say.
That's right.
We're talking about any sex. So this was right at this moment. And so what they were trying to get at was the seducer who would go to these young girls and promise them lots of things, right? They weren't rapes. And then they would ruin these girls, right? Because they weren't marriage material anymore and force them into a life of prostitution, right? And the girls were really harmed. So there was the feminist component, which is these guys are doing terrible things, lying and ruining these women. And then there was the moralistic component. And these women are going to go into prostitution. They're going to give the husbands diseases, and the diseases are going to be brought back to the good, married women. Right. So there were those two strains of it. And for a minute there, at least according to the historians I read, there was a real coming together of all kinds of feminists. Because what the men were saying is, if we raise the age of consent, these like teenage grifters are gonna cajole us into sex and then threaten us, with these lawsuits and criminality, so we give them money. And so all the male legislators were saying that. So then, what Willard realized was, well, who are these grifters, right? They're low-class women, laborers, women of color. I have to bring them into my movement. And so there was that moment, but then, after the turn of the century, and historians have talked about it, the temperance movement got really conservative again. Mm-hmm. And in the end of the day, where did all these sex regulations go? They went to ensuring that a lot of young girls ended up in reformatories.
Yes.
Yeah. So, it ended up with the incarceration of women, so much so that they got a building spree in the 1920s of girls' reformatories run by women, right? And that was sort of this paradox. And one other tidbit I'll put in, and I'll tell you the story if you want, but it's a long story. There was this famous confrontation over the wildly successful rape reform of the temperance movement. So Frances Willard was touring Britain, drumming up support for these kind of reforms. And she got into a row with Ida B. Wells, who charged her with going to the South to, whip up the enthusiasm for these age of consent reforms. And she whipped up enthusiasms for lynching.
That's right.
And so if you could just imagine these two, really prominent women activists of their day sitting in these tea rooms, because, they like to host, the Americans in the tea rooms, and they divided the aristocracy over who was like a Willard person and who was a Wells person. Wow. Because Willard was on the side of temperance and the women, and Wells was on the side of abolition and anti-lynching. And so that was very interesting. But another interesting part of it was, Ida Wells definitely dressed down Willard. She said, you encouraged the lynch mob. But another group of women Ida Wells went at was sort of philandering, loose white women who, seek out black men, have sex, and then claim rape to keep their reputation. Now, I'm sure that happens sometimes, but Ida Wells said there are scores of these women, these, lion, promiscuous women, which is, a very kind of sexist way of putting it. There's scores of these women, and the reason that white men don't want to hear about it is because it reflects on the character of their women. So it was this really interesting thing where, there was good and there was bad in everybody, but we just don't get that story.
In the meantime, there are hundreds and then thousands of black men across the South and the North who were being hanged from trees and burned alive because of accusations that they had raped a white woman, right? And you're saying that this is sort of was stoked, or at least this is Ida B. Wells's claim, which at least we think is partly true, right? At least stoked in part by feminist discourse about the uncontrollable rapists run amok. Now, they didn't racialize it often, although Susan B. Anthony and
yes, she was leveled charges of racism. Yeah,
and Elizabeth Cady Stanton were outright racists.
Yeah.
Outright racist. I don't know if they talked. They did. Yeah, no, they totally talked about black rapists, right, during this time. Yeah. So that's another result of feminist, campaigning for action against rape was, a lot of black men hanging from trees.
Right. Right.
Yeah.
It's interesting now because that history I've been seeing contemporarily in discussions of the Amy Cooper video. Have you seen that video?
The Central Park.
The Central Park birder,
yes,
the birder, Christian Cooper and Amy Cooper.
Yes.
And people are saying, what's so outrageous about this is, it like taps into this history of white women falsely accusing black men.
Right.
And all of a sudden this history is like really relevant that there were these false accusations, right, against men, and they had a racialized component. But like what a lot of the commentary I've been reading in the media doesn't say is these accusations were almost invariably sexual in nature. And then where does that put us? Because like, let's just imagine a slightly different scenario where Amy Cooper accused Christian Cooper of sexual misconduct in the park.
Yeah.
Do we then fall into the believe all women? It's just very interesting that depending on the context, we can admit that history doesn't easily produce heroes and villains. Mm-hmm. But it's like we need some other like more subordinated identity to hang on to.
Right.
So yeah, it's very interesting how these were pretty wildly successful criminal law reforms, and they predictably were very racialized and affected certain segments of society. And I'll also add that there also is a racial history to domestic violence. So, rape and domestic violence were known in the South as Negro crimes. Mm-hmm. And so when certain legislatures were drawing up their disenfranchisement rules to immediately like disenfranchise black men who had gotten the vote, they were like, we're going to put in rape and we're going to put in domestic violence, but we won't put in murder. We won't put in murder because that's what white people do. So, it's just this interesting history where these crimes against women were, they reinforced and reflected patriarchy in many, many ways, but the punishment of the crimes against women also reflected patriarchy and really reflected and reinforced racial hierarchy. Right. That's like a huge part of that story.
Yep. Speaking of race and feminism, there's also, and you lay this out in your book, the nexus of feminism and immigration restriction beginning in the 19th century. You want to talk about that story?
Yes, this is good because this is all like in chapter 1 of my book, which is the historical chapter. Yeah. And I'm glad you like it because I'm like, I don't know if I should do this chapter.
Oh, it's great. It's perfect.
Yeah. So the white slavery, line of arguments is known well, and it has really been resurrected crazily in the modern era to really make this equivalent between women engaged in sex work and enslaved, black.
You said white slavery. White slavery. Yeah. So I know. So
white slavery.
A lot of the audience knows that, and some of them don't. So can you just explain what that is? That phenomenon.
So white slavery was that discourse that women engaged in sex work / prostitution, right? Commercial sex.
Well, they were enslaved by.
That they are being enslaved
by usually immigrant men.
Right. Jews and their dens of iniquity was the first mention, I think, in England in 1850.
Right. And so This is like
Yeah.
so this is like late second half of 19th century and early 20th century is the white slavery panic. This is what we're
Like
talking about.
heyday culminating in the 1910 White Slavery Act,
Right.
also called the Mann Act, which
Yep.
is transporting across state lines for
Right.
sexual commerce. That Mann Act still exists.
Yep.
They were thinking of charging Elliot Spitzer with Mann Act violations at one point, which was crazy.
I know.
But so this white slavery narrative was very popular in Britain because feminists were fighting, temperance feminists were fighting with the government over whether to see prostitution within parts of the city as a public health issue, right? With sort of controlling disease and controlling the commerce, or a criminal issue. And feminists were very much, this is criminal, it's immoral, right? So having this discourse of slavery helped them a lot. And especially with the enslavement of Black individuals in the United States, with that being abolished, now we have all these abolitionists who could put their energy to this new form of slavery.
Yes.
And from the outset, the discourse is wild because you hear people saying of women sex workers, this is worse bondage than Uncle Tom ever knew of. This is, but besides what's happening to this women, chattel slavery seems a benign practice. I mean, it's really wild stuff. And racist because they are, basically ignoring all the harm, sexual and otherwise, that's kind of inflicted by violent whips on enslaved Black people, and saying, oh, just being in commercial sex is worse than that. So there's this real moralistic and racist sort of false equivalence there. But it was a great narrative. It was a great narrative to see that white girls are trapped and enslaved. So most people know of that story, but they don't know that before the white slavery, there's another little part of it. The yellow slavery story.
That's the big part. That's the big part of it. Yeah.
That's a big part. That's a big part that I concentrate in my book, because when I was going to research white slavery and write on the Mann Act, and a lot of people have written on that.
Right.
But when I found this yellow slavery component, I went really wild because it was just so stark and so related to a lot of contemporary issues I was seeing when I wrote on human trafficking in New York and what some of the immigrant Chinese women were going through in that situation. Okay, so I'll tell you a little bit about it. It was 1870s. Yellow peril is in full swing. And, people are just calling Chinese immigrant laborers the vilest, foreign, worst thing. So there was a small trickle.
Lynching in the streets of San Francisco?
Lynching in the it was just, and in a way that was slightly different, right, than sort of Reconstruction era South, where there was an Americanness to former slaves, that they're anti-Blackness. So people were wildly anti-Black in the South.
Right.
But in a way that just had a slightly different discourse than on the West, where the anti-Chineseness was really about exotic and different and disgusting and, unknowable in those ways, right?
Inscrutable.
Inscrutable. Exactly. And, just like the pictures of the Chinese people and how to tell a Chinese person were crazy. And it actually reminds me of something I'm close to, because my mom, who's Asian, she was actually in an internment camp. So by the time that happened, they had the posters, which the Chinese favored, of how to tell a Chinese from a Japanese, and they put those next to each other too. But anyway, there were posters of, how to tell the morphology of the Chinese, really terrible stuff. So there were not that many Chinese women being sort of imported into the United States, right? But when they finally found out that there were some Chinese women coming, they were calling them female coolies. And they were saying that they were in a state of servitude as the lowest, basest, most subhuman people, and that they were culturally and possibly even like genetically, but it hinted that they were culturally and socially inculcated to slavery. That this was even worse than white, prostitute sex workers, because they at least fought back a little, but these women were the lowest of the low. And and not only was this slavery just abhorrent and the worst thing, also, it was spreading exotic disease, right? And so the founder of the UC Medical College undertook a study to see whether the imported Chinese women were poisoning San Franciscans' blood, right? And so they had these hearings in front of the California legislature on sort of banning these women from coming, and they had all this scientific evidence about whether they have exotic diseases, carried syphilis, and then the third thing they could produce were a mongrel race, right? So those were the three elements of it.
Now, to be fair, or I don't know if this is to be fair, just to clarify,
Yes.
a lot of Chinese women in San Francisco during this period were in fact sex workers.
Oh yeah, almost all of them.
Yeah, right. Okay.
Almost all of them. There just were hardly any of them, right?
Yeah.
Like they were a very small pool of people. And the thing about the slavery sort of discussion was there was this interesting phenomenon where some of the women, and I, again, this is not my archival history, I've sort of relied on others' history books, they were actually in the sex work business back in China. Not paying very well. They were, concubines and different things.
Mm-hmm.
And so when they came over to the United States, they were still in that business. But because there were no in-laws of the men and no social mores, they actually had a better chance of moving up into legitimate marriage and out of that line of work, or have a better place as a concubine. So they were actually contracting the women for better things, right? Like, so that's one of the stories, but that they, it's probably fair to say they didn't have the greatest lives in the world.
Right.
But this slavery narrative was at once one of, we feel terrible for these women, and at the same time debasing their women. They're kind of inherently slaves.
Mm-hmm.
And so, the California legislature did pass an act excluding debauched women. And they, were doing these immigration purges, and that led to the first Supreme Court ruling that the federal government had plenary power over immigration, which means, the states can't kind of like just have their own immigration policies, which then in turn led to the Page Act. And the Page Act was the very first federal immigration act ever. Yep. And it was an act to exclude debauched women. And so, these feminist-ish, I always say there were a lot of things that led to yellow slavery, but the feminist discourse of slavery and women was one of them. And there were feminist mission homes where they were rescuing the women. But this discourse of sexual slavery led to the very first Immigration Exclusion Act, which paved the way for the Chinese Exclusion Act and everything, necessitated the first methods of immigration enforcement and surveillance.
Right. So the nexus of feminism, the rape issue, and immigration led to the Page Act of 1875, which restricted immigration of women from China. And then ultimately the Chinese Exclusion Act, the famous Chinese Exclusion Act of 1882, which cut off all immigration from China. Right. So there's another contribution of feminists to not mass incarceration, but the heavy boot of the state on people.
Well, but they also say that the forces organized around the Page Act and later the Mann Act, the sort of vertical organization of policing and police forces, federal police forces, federal immigration forces, and their surveillance method did give rise to the modern FBI and the modern way of policing.
Well, so those are related too. Yeah, so the Mann Act of 1910.
Yeah. But still, the immigration enforcement on the border also necessitated, record keeping and surveillance and policing.
Yeah, Jessica Pliley.
Yes, Jessica Pliley. Yeah.
I've written about that. So yeah, it was the 1910. I mean, you're right. It's all leading up to this, the anti-Chinese stuff. But 1910 Mann Act, which we've talked about already, gave birth to the modern FBI. So that the FBI was actually founded in large part to enforce the Mann Act and to enforce anti-prostitution laws. And then because when they ran out of prostitutes in the United States to bust, they started to look at immigrant women. And so they actually sent agents to Europe and other countries, and they would stop women at Ellis Island from coming in who might have been sex workers or might have just been promiscuous or might have just slept with more than one man in their life or something, right? Right. They either were incarcerated, or more likely they were deported or not allowed in, right?
Right.
So
Right.
so again, there's,
Right. And the Page Act led to the virtual exclusion of Chinese women from
yeah,
San Francisco. I mean, it
completely.
worked.
Totally. Yeah. So again, not great victories in the history of feminism here. Things not to be
Or
proud of.
great victories, right? Like,
Well,
depending on how you look at it.
right. Certainly. I mean, for the people at the time, they were considered to be great victories. Yeah. But for nowadays, the typical woke feminist would not look on this history and be, I would hope they would be at least somewhat embarrassed by it. Okay. Then we move, unless I'm missing something, then your book moves pretty quickly to the 60s and 70s, right?
Right. Like, so I roughly am going on waves of feminism rather than like a
Sure.
linear history, because
Sure.
from what I read, it was fairly quiet throughout, the post-war period up until the 60s, which brought a renewed surge of energy
Sure.
to thinking about these kind of gender crimes.
Well, also, I mean, that's the emergence of second wave feminism too, right?
Absolutely.
Right.
Right. So this first one was kind of temperance, first wave-ish,
Right.
progressive era feminism. And then the second one is second wave feminism, which is very powerful. And most people, when they think feminism, they think second wave feminism.
Right. So, okay. So then you talk about the rise of what you call legal feminists, right?
Yes.
This is that's your terminology, I think, right?
Yeah, I just made that up. Right.
Yeah, which is totally fine. So you sort of divide second wave feminism into three camps, but the one that you see as being ultimately victorious and dominant is what you call the legal feminists, or I guess carceral feminists, right? So you're talking about, or the original carceral feminists.
Right. You're right. Exactly. I mean,
Okay.
Carceral maybe. I mean, if you see it all of a piece, but they were at least pro-policing.
But you know what?
They were very pro-policing.
Yeah. So actually, you know what though? Let's talk about the people they eclipsed. And this is another thing I did not know about until I read your book. So thank you again. The shelter movement of the 1970s, which you describe as anti-authoritarian. Eventually, according to you, they cave into the legal feminists, but originally you're saying they were anti-cop, anti-state, anti-authoritarian, just interested in protecting women from violence and sexual assault. So
I would say almost every left group out there in the late 70s was anti-carceral when it came to DV.
Wow.
Almost everybody. And
Wow.
by the mid 80s, what we had was a carceral DV movement. And it's fascinating, like how that just happened, right? So if you go, you look at what's happening now, right, with the police. And every day I had to get off like Twitter a little bit because there's just so many videos of cops beating people up. I mean, it's like, my heart pumps and I just feel horrible. Well, that was kind of like the late 60s. I mean, we didn't have Twitter back then, but there, especially amongst young people and progressives, which is really anti-police moment, even within the police. Just like right now, what we're seeing, it's so funny how it's so similar. Right. The police were kind of like, nobody likes us. We're going to try some community policing, right? We got a really bad rap in certain places, right? Certainly not all cops. Maybe they dug in after the protests. But so this was a moment of radical awareness, right? Where people were really anti-government, really anti-war, anti-police, including feminists who were leftists, right? And the fact that the main thing that came out of this moment was a mandatory arrest policy blows my mind. So let me just break it down a little bit.
Yeah.
So out of that 60s sort of energy, there were several even groups of feminists, some that were more or less concerned with domestic violence. Obviously we had the women's movement that was really concerned with women being in the workplace and women's workplace equality. And we might think of that as like now. We have the anti-poverty feminists who are more radical. We might think of the, labor rights and welfare rights organizers, and they kind of clashed with now. And they were, kind of tangentially related to the early battered women's movement. So you had shelter feminists, and I would put them more into like anti-poverty camp, really radical. They envisioned that they would have these shelters for battered women, and it would be a grand egalitarian experiment. Everybody would be equal. It wouldn't be run in a hierarchical way. It would be run from grassroots energy and grassroots money and self-sufficient. And they found themselves in a really tough place because they could either take money from the state, right, to run these shelters, or they could go to private donors. Well, the state they thought was a Vietnam warmongering, dirty hands entity, so they hated that, right?
Mm-hmm.
And then the private donors were all these wealthy capitalists, and they hated that.
Right.
So it was really this huge dilemma, and you see in the writings of the shelter feminists at times how much they struggled with getting that bureaucratic welfare money that they thought was so dirty, and how much they struggled with making these reforms so that the state could quantify whether or not they were a worthwhile organization to spend their money on. So they were really radical. And so that was their sort of first battle. And so then, the policing people at that time where the shelters were being formed were mostly social scientists. And there were three social scientists that were really important at this moment: Strauss, Gellis, and Steinmetz. And they were doing these studies of violent families and sort of tracing them to a lot of these social factors like, job stress and racism and economic stress, and family factors like pregnancies and things like that. And, they were also weighing in, the social scientists. So then we kind of have this culminating event that really launches in the government and in the society, the modern domestic violence movement. And it's the 1978 hearings in front of the Commission on Civil Rights. And the audience soon, created the coalition, the National Coalition Against Domestic Violence. So the first rift that happened was actually between not very carceral feminists, left feminists, these anti-poverty feminists and these anti-patriarchy feminists. So the shelter feminists were kind of in both of these camps, but basically the anti-poverty feminists and a lot of the Black feminists were saying the following: what we need to deal with domestic violence is a recognition that society is broken in many ways. Mm-hmm. It's capitalist, it's racist, right? The feminists of color said it's racist, and and people are poor. Yeah. And so what we want is money. Just give us money and don't add strings attached to it. And in fact, there's one amazing moment in the hearing where this woman named Fernandez tells the story of Marta Segovia Ashley. She founded La Casa de las Madres, the first shelter in San Francisco, which still exists.
Oh, wow.
And she came up and told the story of Segovia Ashley's mother, right, who was stabbed to death by the stepfather and then pushed out the window to make it look like an accident. And that sort of, then she founded the shelter. But the upshot of that murder, according to Segovia Ashley, wasn't that men are evil, stick them in jail. It was that it was the final act of a white supremacist society determined to lead two people to annihilate each other.
Wow. So structuralism here, right? This is like extreme structuralism.
Extreme, right? Structural Marxist, race, conscious. Right. And so then a feminist named Judge Lisa Rachette, who was the feminist of Philadelphia, had been one of the first women to go to Yale Law, then was on the faculty, first DA, first judge, and a real feminist. She sued to be able to wear a pantsuit, right? Like that's like feminist as you could be.
Wow.
And she goes to the mic and she says, I have to disagree with everything that Shelley said, that this is a problem of white versus Black. This is a problem of all women. It happens in the, quote, ghettos. It happens in the fancy things. This is no other than the problem of patriarchy, and it will never solve patriarchy by giving money to poor women, basically.
Wow. Yeah, right.
Right? And then she closes with, and I'm not going to rest until women are, until the oppression of women is taken as seriously as racial oppression is. Oh, okay, right? And then the crowd claps and claps. So this was that rift. Whether or not we were going to see this as a multifactorial thing of which patriarchy is a part of it, but other things, or whether we're going to see this as just the patriarchy that affects rich women and poor women equally.
Right.
And that won the day. What Beth Ritchie, a sociologist, has called the every woman narrative.
Yeah. So just so people are clear, so it's a causal claim, right? So one side is claiming that rape is essentially caused by poverty primarily in the capitalist system generally, right?
And race. They were very racial discrimination.
the structural systems, but in particular, poverty
Yeah.
caused allegedly by capitalism and racism.
Right.
Okay.
Right.
That's what causes men to rape women, is what
Right.
one side of, okay. And the other side,
Well, this was DV. This was mostly in the DV discussion.
yeah.
The
And
domestic violence. Yeah.
okay, right. And the other side is what you're calling the anti-patriarchal side, which is arguing that no, it's about the problem is men and their power, their disproportionate power, their dominant power in the society, and internalized beliefs about the patriarchy that's causing men to rape women or allowing men to rape women. Right. That's
right.
So it's the two causes.
Right. It was meant to beat women on this one, because rape was hardly mentioned at all in the domestic violence these discussions.
Right. And so this is so interesting. So again, another thing I learned from your book. So the anti-patriarchal feminists won this debate and ushered in a whole era of a whole bunch of laws and a whole bunch of female, often prosecutors, right? And who were quite zealous in prosecuting these cases. And this contributed to the fact that we now have 2.3 million people in prison.
Absolutely. Right? So if you look at so the anti-patriarchal feminists are interesting, because even Judge Rachette, she was like, okay, and so what do we need to do to dismantle the patriarchy? Right? We need to have housewife wages, fair tax base, economic distribution, all these really lefty sort of structural changes, just in the name of patriarchy. Those were non-starters for a lot of people. So what the patriarchy established was, it ain't poverty, it ain't race, it's not structural, it's men. And not only is it men, but it's bad sexist men enabled by lax laws. And we know it's not anything else but that, because there are a lot of poor men who don't beat women. There are a lot of black men who don't beat women. There are about a blah, blah, blah who don't beat women. So it can't be any of that stuff. It must be this pool of sexist, violent men who are allowed to get away with it by the law, right? So that patriarchy, that general let's dismantle patriarchy claim, then morphed into a very specific legal failure claim, that it was the failure of the law to control a certain group of men that causes abuse. So a very criminal law type of ethic. And so this became how do we strengthen law and law enforcement to effectuate this change where men are afraid of the law and therefore they won't beat, because we've now reduced the entire world of the predicates of family abuse into the failure of the law to deter violent men. Right.
So now then, how did this play out in the courts, et cetera, and on the streets over the last 30 years when we saw mass incarceration really take off, especially with the crime bill of 1994? But the spike begins with Reagan and then spikes again under Clinton. So how, in those years, how is feminism implicated?
Yeah, so there's a really interesting story out of Oakland. Like, one of the things I said was that in the 70s, police were also thinking, we're kind of in trouble here. How do we be community policers? And so part of that was these, non-arrest policies. So try to mediate out some of these offenses. And so feminists came in and said, wait a second, you're mediating out DV offenses and not arresting, and these women are going to end up dead, right? And so we're going to sue you, police departments, and we're going to force you to arrest for domestic violence and not mediate out these cases. And it was interesting because the Oakland Police Department came back and said, but we're not discriminating against women here, because these were equal protection challenges, discrimination, gender discrimination. And they said, well, we're not discriminating against women because our policy is not to arrest for any misdemeanor simple assault and to try to mediate it out first. Right. Men on men, women on women. And they said, no, we think it's going to disproportionately impact women and blah, blah, blah. So they ended up victorious, as in consent decree victorious, as they were in New York. And, police quickly adopted these policies of preferred and mandatory arrest. And in short order, the police loved them, because it turns out they didn't like being mediators. They like to arrest people. That's what they were trained to do. And that's what they wanted to do, right? They wanted to bust up in there and arrest somebody, that's policing, in the ethos of policing. You look at Derek Chauvin, or Chauvin, I don't know how to pronounce it, the one who had the knee on the neck of George Floyd. Something that's striking is he won a medal from the police department for responding to a domestic violence call by breaking down the door and shooting a guy, right? Like, so that's right. That's that's interesting that he got a commendation medal for that. Another one was for shooting another guy.
There's the Gruber thesis right there. Wow.
Right? I mean, so it's funny because police did hate domestic violence calls back in the day when they had to be mediators, and they hated going there because A, they were very, very dangerous. I will say that. DV calls are very dangerous to police officers. But B, I mean, how unsatisfying to get there and like, she doesn't like you, he doesn't like you, you can't make it an arrest, nobody's thanking you for being, you know, like the men in blue. This sucks, right?
Yeah.
So within short order, police were like, we are totally down with the arrest policy, right? And even one legislature, in supporting mandatory arrest in 97, there was all this social science evidence that came up that, you know, these policies might escalate violence and make things worse off and are especially bad for Black women. Like, don't do them. So the opponents brought up this, this evidence that mandatory arrest, you know, makes things worse. And what the legislature said, well, we're going to pass it anyway because it's unfair to the police officer to make him be anything other than an enforcer. You can't make him be a social worker.
Right.
So then the police became the reason why we like mandatory arrest.
Jesus.
Right. It was kind of wild.
So I got a personal story here. So 10 years ago, I was living in Los Angeles, and I was living with my girlfriend at the time, and we had a tempestuous relationship with a lot of fights that were not physical. Actually, she was physical with me a couple times, but generally it was just yelling. And I was never physical with her, and you'll just have to believe me. But one night we had a large shouting match fight in the house. And then I went into the backyard, and there was like a large cardboard box, which I just kicked a few times out of anger. And I guess it made a lot of noise.
Oh boy.
And about an hour later, there's a knock on the door, and there's 4 LAPD. And there's 2 squad cars right in front of my house. And they say, I'm sorry, sir, we just got a call from a neighbor saying that there was a domestic violence going on here. And I said, oh, really? Well, there is none. You know, you can talk to my girlfriend if you want. They said, no, we have to enter your house. And I said, where's your warrant? And they said, we don't need a warrant. I said, of course you need a warrant. I wish Gruber had been with me at that point, because she would have told me to stop resisting. So I was increasingly belligerent with them because of this. I didn't know about your book. You know, I didn't know about all this stuff. I didn't know that cops were obligated by the courts to enter a house when just a neighbor calls them up and says, I think there might be domestic violence going on at 2025 Granville Avenue. And that's not my actual address, by the way. And so I was like, you know, giving them lip, and then they sort of just like walked in forcibly into my living room, and I'm getting increasingly pissed off at them. And my girlfriend is in the bedroom, so they haven't even seen her yet. And then they say, sir, can you come into the kitchen with us while we go talk to your girlfriend? I said, no, I'm not going to go anywhere. I'm not going to move. At which point, the little tiny white cop with the crew cut just said, that's it. And he went behind me and handcuffed me. And they took me into the front of the house and had me stand on my yard with 2 squad cars there and cops holding me there while they went and talked to my girlfriend, who said, yeah, nothing. It was just an argument. And that was that. And I said, I need to talk to your supervisor, guys. And I'm standing there in handcuffs. And so I waited for half an hour while they called the supervisor from the precinct or whatever. And he came. And he explained to me basically what you've been telling me, that the courts required them to do that. And I still am blown away. You know, like I thought you needed a warrant to enter someone's house, but I guess not anymore. And thank you, feminists, I suppose.
I mean, it's interesting. And it's kind of like, it goes back to what we said earlier with, you know, the media always having the spectacular cases, but there are egregious cases where women were being beaten and they got restraining orders, and you know the police just didn't care, and they were multi-million-dollar verdicts and horrible cases.
Of course.
You know, but that's the thing about, you know, basing policy on individual cases.
Right.
You can't do that. So when you look in the aggregate, what's interesting to me is, the last two people who've come and talked to me about the DV charges against them have been people I know, like friends of friends, who are women. And the interesting thing is, if you had said what you said to me, like your girlfriend said you didn't do anything, but you said, she hit me, they would have arrested her.
Mm.
Right? Because she would have been the primary aggressor and would have violated a misdemeanor law. And so that's also happening sometimes too, either dual arrest or not.
Okay.
With the warrant, I don't know if they'd have to have a warrant because exigent circumstances,
Okay.
a DV call is always exigent, because we have this narrative that also was born in this sort of domestic violence movement, that if you ever let any instance of DV go, the woman's going to end up dead. Right?
Mm-hmm.
So you've got to arrest him now. And the fact of the matter is, like all homicides, domestic homicides are exceedingly rare. And incidences of domestic violence are exceedingly common. Many aren't reported because people are seeing them as minor, right?
Mm-hmm.
Or they just don't want the cops in their business, or they don't want people arrested. So that's not true. And in fact, a researcher out of UC Berkeley, and found that it might be the case that mandatory arrest policies increase the chances of domestic homicide. Because if a woman has a bad experience with calling the cops because the spouse got arrested and she didn't get the service she wanted, was traumatic, she might stop calling the cops to intervene, right? Like, and that one time might be the time he kills her. And so she found that sort of a correlation. So it's interesting, all these narratives that arrest works, arrest prevents murders, they seem really intuitive. When the researchers got down to it, they found out that depending on who you are, arrest was more or less effective on deterring you from abusing. So if you were an employed white man who, lived in a certain area, actually was pretty deterrent, right? So again, for that group of people, it was a deterrent. If you were an unemployed Black man, it actually increases the incidence of domestic violence. And, some feminist reaction to the study that found that DV arrests could have escalatory effects and negatively impact Black women, some of the reactions of feminists who seemed pretty racist. There's this one quote I have in my book where a feminist said, oh, well, Black men, right, they don't respond to arrest. Well, that's not an argument to treat them less harshly. That's an argument to treat them more harshly. Because, and she said this, I have this like seared in my mind. She said, quote, in some subsets of, what did she call them? All right, she said, in some subsets of ghettoized society, right? Society's losers are basically used to being in jail and might see a day in jail as a slap on the wrist or a rite of passage. So the fact that these ghettoized people don't respond to harsh punishments is just a ground to make them harsher.
Yep.
So, I mean, that's pretty close to saying what, people said in Reconstruction about slaves being immune to, all but the harshest abuse. And I couldn't believe it. This was from a very good feminist, like a very good feminist.
Wow.
Yeah.
Wow. Okay. So I couldn't help but notice that two of the leading Democratic candidates for president this year were female prosecutors, Kamala Harris and Amy Klobuchar. And I don't know the numbers. Do you cover this in the book? But, so with the American left in general, what happened with them, and I know this very well because I come from this, they had their heyday in the 1960s and early 1970s, and then the movement kind of petered out, and the Vietnam War was over, the civil rights movement was over, second wave feminism had won many of its great victories. And so what did the left do? They entered the academy, became a bunch of professors. That included a lot of feminists who then went on to found things like gender studies departments. But I found out from your book and from watching Kamala Harris and Amy Klobuchar operate is that a lot of feminists from that era and since didn't go into the academy, they went into prosecutor jobs, right? Law enforcement jobs, and brought with them a lot of these ideas that you've been talking about here, right? So is that, how much of that because I've heard, the work of John Pfaff on mass
Yeah,
incarceration? Yeah.
yeah.
I mean, his argument, I believe, is that it is, and I don't even know if he's right about this. I've had arguments with him, but his argument in his book is that mass incarceration is largely, I believe, caused by overzealous prosecutors over the last 20, 30, 40 years, right? Acting on their own. He doesn't really explain why they decided at that moment to act on their own to put more people in prison, but that's his argument. Now, I wanted to know, and I don't think he covers this, how many of those people are women acting on this ideology that you've been describing?
I can't answer that question. And again, I'm sympathetic to the ideology because it's one I had, that this was like a real side of gender justice. I think, I'm hoping that my book can speak also to some of these progressive prosecutors who are like dialing back everything, but we're going to go extra hard on rape and DV, extra hard on those, that, maybe those shouldn't be a carve out, right, from their carceral critique. But I will say this is statistically what I did look into because I just kept hearing this argument. So one of the things that rape reformers say, and rape laws are still being reformed to be more carceral, and all kinds of sexual misconduct laws, is that, if we're going to decarcerate, let's start with the nonviolent drug offenses, then we'll even go to the violent offenses, but we should never start with the sex assault offenses or the DV offenses, right? We wouldn't start decarcerating there because they're gender justice issues, right. Number one. And number two, they're drops in the bucket. I've literally heard drop in the bucket. And every time I hear drop in the bucket, I have to remind people that if you go to the Department of Justice Bureau of Statistics and look up the incarcerated population, that's state and federal incarcerated population, and how they break it down by crime, right now for 2018, which is the last year I could find, about 15% of all federal and state offenders are drug offenders. Okay,
right. Yeah.
So that's not nothing. I mean, 14% of all state and federal offenders are sex offenders.
Sex offenders, right? Yep.
Right, and these were felony charges. So I mean, that's almost as much as all drug users and dealers, right? That is not. Nobody could call that a drop in the bucket. Now, I think that's due to sex offenders staying in jail longer and not necessarily there being more prosecutions of them. It's just once they're prosecuted, they stay in jail like forever and ever and ever and ever.
Okay.
But still, I mean, that's still carceral. It's not a drop in the bucket. And we also know this. We know that domestic violence policies, number one, directly led to more women being arrested. And number two, changed police and other people's views on whether any violence is tolerable. You can just let it go. So no. So the answer to those two questions were no. No violence is tolerable. It doesn't matter who committed it. It doesn't matter why. It doesn't matter how minor. A slap is like abuse. So, we've seen the increase by 30% of women being arrested for assault. And I think, part of the narrative of arrest everybody for domestic assault and arrest everybody for assault is that, again, we get back to that benign discrimination. Police were going in there and seeing a violent couple and they'll be like, we'll arrest him. Well, if you tell them you arrest everybody, they're no longer going to exercise sort of the masculinist women are, victims thing. They're going to be like, doing my job, arresting everybody, right? So, those aren't great trends. I mean, arrests have gone down over the past several years, precipitously, but not domestic violence arrests.
Wow.
Yeah. Wow. Yes, those have stayed stable. So.
Wow. Okay, so your book includes a list of prescriptions, which is nice. A lot of academics don't do this, but you actually offer some solutions. Why don't you tell us what you think should be done to solve these problems, or at least ameliorate them?
Well, I think we should start thinking as feminists, and I still include myself as a feminist because I believe that there is such thing as patriarchy and that gender crime does reflect and reinforce some inequalities. It's not the only player, but how can feminists think about being non-carceral? I'm really glad this book is coming out now because there's this big abolition movement sort of popping up right now. You see a lot of people into prison and policing abolition, and a lot of women are on the forefront of that, which is really interesting. Women of color.
Mhm.
And so they see it as a gender justice issue in that police, when they come into especially blighted neighborhoods, whether black or white, really, when you think about it, they're most of the time causing more damage. And when they cause damage to these community societies' children, a lot of the time women of color will bear the brunt of that, right? So they will bear the brunt of the dysfunction and the fact that policing was escalatory. So they see it as a gender and racial justice issue. So I suggest that, there are many other ways we can do feminism aside from putting people in jail. And in fact, if you're me, you think that the whole concept of jailing people and of like exercising that kind of authority over them and putting them in spaces of sexual violence and then celebrating the sexual violence when they is not very feminist. So I actually would say be anti-prison, but if you don't want to be anti-prison, I'm sorry, this is my husband's computer. If you don't want to be anti-prison, you at least don't have to be pro-prison. So one thing that struck me all throughout these Title IX debates, and like, what's the best way to address campus rape? What's the best way to address campus rape? Everybody I met, from the Janet Halley side, sort of, anti-Title IX feminist side, to the pro-Title IX feminist side, all agreed that early, as in grade school early, sex education, not sex is dangerous and horrible, sexuality as in pleasure, consent, relationships, how to have sex, how to have good sex, all that, this is necessary. And there was no sort of person like clutching their pearls and saying, like every activist in the spectrum agreed with early sexuality education. And yet, when you hear the zillion things people are talking about in Title IX, it's hardly ever that. That's the harder one to do, right? That's the harder one to get parents and legislatures and stuff to go for.
Can I break in just for a second here?
Yeah.
And strike a discordant note here.
Yes.
Sex education. So I don't know what I think about that. I definitely do not like the idea of the government of any of the states or of the United States teaching my child about sex. So if that's what they're calling for, I am not with it. If they're calling for a cultural shift, a broad cultural shift in the way that we talk about sex with children, I'm all for it, especially if it's sex positive feminism that we're talking about moving toward. But too often, I think what they mean when they talk about sex education, don't you think, is the government teaching our kids in public schools about sex, which I think is just one of the most ridiculous ideas. Who would be in favor of that if they step back from it and think about it? You want the legislature of your state, whatever your state is, I'm sure you have negative feelings about it, or the president or the Congress deciding, what is taught to your child about sex.
Right.
Ridiculous. Anyway, that's it.
I totally think you could be against how to structurally implement, a sexually educated, society, right? Like, so I think the principle is, I think that a lot of these things are happening on campus because of repression and lack of discussion about sex and nervousness, and that leads to drinking, and drinking leads to a lot of the miscommunication. And everybody's kind of on board with that. Now, how you administer that, I agree with you. I think your thought that the government doesn't teach sex ed, that ship sailed like so long ago, because they're teaching like abstinence and, like diseases.
Even if they're not, like, why trust a stranger hired by the government, again, to teach your, 10-year-old child about sex and their body?
I don't know. I'm not an expert on delivery of education.
I know. That was sort of
that's kind of like out, but it's just an interesting thing. I think where the energy was placed towards, if you want to be like, libertarian in that space, way more governmental solution, like actually putting people in jail. That, or, kicking people out of school and not letting them get any education. Sure. That is sort of where the minds went, instead of like, how can we, create, whether culturally or not, the conditions under which this doesn't occur.
Gotcha. Yeah.
And nobody really had a debate about that. They would just kind of ruminate like it was pie in the sky, kind of like what the anti-poverty feminists felt back then when they were like, well, give women money, and they'd be like, yeah, sure. What about education? Yeah, we all agree with that, but we've got to do something. So it's okay. I think there's some instant gratification in calling for criminal law. It's very gratifying. It's very gratifying.
Okay, so you want better sex education, whether it's just cultural by parents or maybe by the government, we can leave up for another discussion. But okay, so what else do you prescribe? How do we get
I
out of
also
it?
prescribe looking into these policing and prison abolition and on the ground community activist groups like Incite, Black and
I,
Pink.
I love Insight.
Yeah,
Vicky Law. I love
yeah, she's
Vicky Law.
great.
Yeah.
I mean, I've read a lot of her stuff.
Insight is all about this. It's almost, I thought about them a lot when I was reading your book. Vicky Law has a great video, by the way, which I've posted a few times. Everyone should look it up on YouTube, about alternatives to calling the cops when there's domestic violence or a possible rapist in your community. It's really, really inspiring stuff. But anyway, sorry, go ahead. Yep.
Yeah, so I talk about Incite. I talk about sort of the mothers in Chicago who would go out and do policing on their block in lieu of policing.
Yeah.
So they would like be passing out hot dogs and stuff, and it kept the block free of criminal activity. And it was really feminist in a way. It was organized by women, for women. It was called the Mothers March. So just ways in, so I who knows who this book will speak to, but like I had in my mind that it could speak to a certain one of my students who kind of grew up in this era of raise your mattress / Me Too, but at the same time grew up in this era of Black Lives Matter, and then feels very conflicted. Like, I don't know what to do because I'm told that I have to be really, really anti-rape and anti-DV and anti-violence against women, and then I'm told I have to be kind of anti-policing and anti-incarceration. So I feel stuck. And what I'm kind of saying to that person is, I don't think you should feel stuck, because I think there's a long history that has tethered feminism to incarceration, but it didn't necessarily have to go that way.
Right.
It just did go that way, so much so that we think it's natural and really radical to break that chain.
Excellent.
But you guys can do it, right? Like, this is the time for you to do it.
Excellent.
So that's what I'm hoping.
I love that.
Good.
Aya, your book's excellent.
Thank you so much.
It's just excellent. Everyone should read it. The Feminist War Against Crime. And I hope everyone reads it, or a lot of people read it. And it's rigorous, it's persuasive, and it's also very accessible, by the way. It's an easy read, but it's very rigorous. You don't dumb it down at all. It's outstanding work by an academic, which I don't say very often, because
I really, you don't know how much I appreciate that, especially coming from a historian, because that's part of like.
Yeah, the history's super solid. Not only super solid, but as I told you, I learned several things from it about a topic I've studied a lot. So it's a truly great book. And we talked about before we started rolling, I'm not a huge fan of academics, but I am definitely a fan of your work. So I'm glad you've done it, and thank you very much for coming on this show.
Well, thank you for having me. It was great.
Good. And maybe we'll talk again or do something together again on this topic. I'd love to pursue this further.
Sure, I'd love it.
Cool. All right. Well, good luck with this book. Everyone go get it. Everyone go read it.
Yes, I feel like I should be holding it up.
Yeah. You don't have a copy?
Oh, I do. It's just downstairs.
Oh, darn. Yeah.
Yeah.
But it's UC Press, University of California Press, The Feminist War Against Crime. You can find it easily. It's on Amazon. Go get it. Thanks, Aya.
Thanks so much. I really appreciate it, Thad.
Take
Bye.
care. Bye-bye. This is the Unregistered Podcast, and I'm Thaddeus Russell. To experience the new Renegade University, go to renegadeuniversity.com. Thanks for listening.